All right, the court is calling 2023 CR.
Here we go, folks. The court is officially calling the case of State of Texas versus Dmetric Jackson. Translation: this isn't just some simple traffic ticket hearing. This is a serious assault family violence case right from the jump. Things are about to get really messy, dramatic, and unpredictable.
0684 State of Texas versus Dmetric Jackson. Can I have parties announced for the record for the state?
Travis Banks in the state of Texas.
Defense.
Largo Garza for the defendant.
All right, you entered a plea on April 19th of no contest, and you applied for probation, and you entered a plea on the offense of assault, family choking, strangulation. Punishment is to be assessed at a cap of 7 years. The state opposes your application. Have both parties had a chance to review the PSI report, state? Defense?
I have, Your Honor.
All right. State, do you have any witnesses?
State has no witnesses.
Defense, any witnesses?
Just my client, Your Honor.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, state your name for the record.
Dmetric Jackson.
All right, you can lower your hand. Defense?
Can you please state your name for the record?
Dmetric Jackson.
Okay. Dmetric, you've applied for probation in this case, is that correct?
Yes, sir.
Okay. Can you tell the court why you think you should be getting probation?
I'm very deserving of a second chance, and I want to be more helpful for my kids. It'll help me stay more focused while I'm trying to rebuild what I lost for my kids.
Okay, this was an incident that occurred, and I believe you told me it was purely an accident, correct?
Yes, sir.
Did you have any relationship with this woman?
No, sir.
Wait a minute, I'm sorry.
Okay.
How's an, I mean, he's pled to assault choking, is that correct?
That's correct, Your Honor.
I don't understand how assault choking is accidental.
Oh, you calling me?
Hold up. Did you actually catch that? The defendant just called choking someone an accident. The judge is basically saying exactly what we're all thinking. Buddy, how do you accidentally choke someone? This isn't tripping over a Lego piece. It's a violent, deliberate act. And clearly, the court is absolutely not buying the flimsy excuse.
Yes, I mean, because you're saying it was an accident. I don't know how you choke someone accidentally.
Oh, no, it was a misunderstanding. I mean, it was a misunderstanding.
How is choking someone a misunderstanding? And mind you, I'm just trying to figure out what you're trying to tell me.
Yes, ma'am.
So I don't understand how choking someone is an accident or how choking someone is a misunderstanding. Now, if somebody said, choke me, and you thought you heard them say choke me, and then you proceed to choke them, I can understand, oh, that's a misunderstanding. I thought you were telling me to choke you, but you didn't. So I'm trying to figure out where you're coming from.
I think you're referring to the whole incident. Is that correct?
Yes, ma'am.
You're referring to the incident, correct?
Yes, ma'am.
Yeah. And did you have any kind of relationship with this woman?
No, I didn't.
Okay. How did this come about? Did she feel that she had a relationship with you, or what? Can you explain that to the court?
We was working on a business plan, and I guess our feelings got more in tune. She was trying to be more than what I was not that more. So
I'm sorry, I can't understand what you're saying.
I said we was working on a business plan, a business deal, and I guess her feelings got more involved in. She was trying to carry on a relationship, a business relationship with him. So, I mean, I feel like she was posting her son. Like, I mean,
and if the court puts you on probation, how do you think this will help you and help your family?
it allowed me to rebuild what, was taken away from me, what was like literally robbed from me. So you know, it's the steps I have to take. I mean, for me to be out here with my kids, I mean, I do whatever I have to take. I mean, I promise my kids that I would give them the remainder of my years. I mean, be dedication to them than what I've given them in the past.
No further questions.
So you said that this was all a misunderstanding, and I was reading in the PSI that you also said she did it to herself. Did you recall telling the PSI person?
Oh, wow. He just seriously said the victim choked herself. That's like telling the teacher your homework magically caught fire by accident. It's the kind of wild explanation that makes jurors and judges instantly raise a skeptical eyebrow. What do you honestly think? Does that sound remotely believable or realistic to you?
That she did the choking to herself?
Yes, because I didn't touch it. I mean,
okay. So it's your position that she choked herself?
yes.
Okay. And you told the TAP evaluation officer that you smoke 8 blunts on a daily basis. Do you recall telling him that?
I used to.
Do you still smoke 8 blunts on a daily basis?
No, sir.
Okay. And do you think you have a drug problem or need drug treatment?
No, sir.
Okay. And have you been on probation before?
Yes, sir.
Have you always completed your probation successfully?
Yes, sir.
Okay, so you've never had to have your probation extended?
I was on probation one time. I don't think so.
You've only been on probation once?
Yeah.
So were you put on probation in 1995 for assault bodily injury?
No, sir.
No?
No, sir.
So if the PSI says that you were, is that correct or incorrect?
Incorrect.
Okay. And you weren't put on probation in 2004 for possession of controlled substance, PG 1 to 4 grams?
Question, no, sir.
So if the PSI says that, the PSI is 1.
Yes, sir.
Okay. And you weren't put on probation for driving while your license was suspended in 2000?
Yes.
That was the time you were on probation?
No, it was in 1994.
Okay. So the 2000 for...
I was on parole. I was in prison for parole. I was on parole.
Which year did you go to prison?
2006.
But before that, no probation?
No probation.
Okay. So you were never revoked from probation
No,
before that? Okay. No further questions, John.
All right, any follow-up question?
No, Your Honor. Rest.
All right, the court will hear argument. State.
Your Honor, I think according to...
Notice carefully what the prosecutor is doing here. He's hammering hard on the issue of credibility. The defense keeps saying misunderstanding, but the state points out multiple probations, multiple revocations, and complete denial of responsibility. In courtrooms, your track record always speaks louder than excuses. And unfortunately, his record is not looking very good.
The PSI, he has been on probation many times. He's been revoked from probation many times. I think he's come to the court and he's misrepresented his criminal history. Furthermore, he's minimizing his guilt. He says that he didn't do it. He says it's a misunderstanding. He even told the PSI officer that she choked herself and that any injuries she might have had, she caused to herself. I will also point out that to the extent that defense tries to argue he had a rough upbringing, he told the PSI officer that his childhood was blessed and that he doesn't need any kind of drug treatment. He also said he doesn't see how probation is going to help him, but he'll try. I think this is someone who doesn't want probation, doesn't want the kinds of services that are available to help improve somebody's life while they're on probation. And for that reason, the state is asking that you meet the cap of 7 years.
All right, defense.
No, you can't.
All right, if he wants to say something, I'm fine with him saying something.
Don't say so. Go ahead.
When he was saying about it wouldn't help me. I was talking about the treatment of the classes, not as for the probation. The lady had called me again yesterday from the PSI, letting me know that she was typing too fast and some of the words got mixed up. And she called me again yesterday and was asking me more questions. Because when I did my PSI, she really wasn't understanding what I was saying. Before it's what she typed on the paper.
Okay. All right, defense.
Well, Your Honor, I think this case has been going on for quite a while. He hasn't been in any further trouble, Your Honor. I think this was an incident that occurred because I think the lady thought that she had a relationship with him and he did not want to. We're asking the court to put him on probation. I believe he knows that probation will help him. He'd like to do what he can to get a job, do what he can for his family, and be there for his family. So we're asking the court to place him on probation.
All right. Mr. Jackson.
And there it finally is. The hammer drops. 6 long years in prison. The judge flat out says, "You're not a good candidate for probation." This is the legal equivalent of saying, "Nice try, but no chance." And remember, once the judge makes an affirmative finding of family violence, that heavy label sticks forever. It follows you relentlessly for life.
I want you to know, I did look at everything. I just don't think that you're a good candidate for probation. What I'm going to do is find you guilty, and the previous judge found you guilty. I'm going to sentence you to $500 fine, time and money run concurrent. There's an affirmative finding of family violence. There's to be no contact with Elizabeth Dahl. Take in consideration 2020 CR 2357, and I'll sentence you to 6 years in the prison. Give you credit for any time served. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do.
So Dmetric desperately tried to frame this entire thing as an accident, even claimed the victim somehow hurt herself. But the court clearly wasn't buying a single deceptive word. Here's the really big question for you. Do you think the judge got it exactly right with 6 years, or should probation still have been on the table? Drop your honest thoughts below, because this case is the perfect example of how flimsy excuses don't fly when the facts and the history simply don't line up.
Not have the court's permission to appeal. Do you understand? All right, Mr. Jackson, if you want, I can ask that you be referred to the therapeutic community. It does not increase the length of time that you're in custody, but it may be able to help you with any drug issues you may have. Do you understand? Would you like that or no?
Yes, I was trying to understand because.
All right, thank you. Good luck to you.